Hi everybody. Welcome to today's webinar. Grateful for you joining and giving up some of your valuable time. Today's topic, as promised, tricks and traps of financing in the Pacific. Today from a lender's perspective. My name's John Ridgway. This is a slide where these two things don't normally appear together. In fact, they don't appear together at all normally, me and housekeeping. But just to be clear on a couple of things, today we're recording the webinar. The reason we do that is we like to be able to make these available to other people later if they're unable to attend. In that vein, we have a number of earlier seminars we've given. If you'd like to get access to those, just contact the team at PLN. We've had a range of seminars this year on governance, the tax office in Australia, dealing with a whole range of other corporate and commercial issues. So feel free to reach out if you're interested in getting a hold of any of those. As normal, disclaimer, these are just my observations and thoughts. Don't take it as advice. And questions we will have at the end, if that's okay. And in relation to questions, feel free to put those in the chat at any time during the course of today, or if you want to wait and ask a question at the end, that's also fine. So two ways of dealing with that. PLN, that's our map. We're in 15 countries, 22 locations, a couple of other things of interest. Almost all of our firms, which are all individually owned, independently owned and operated firms in our network, are owned and operated by Indigenous lawyers in those countries. The other stat that we're particularly proud of is over 60% of those firms have a 50% or more female ownership and management of them. So that's something that we're extremely proud of. Three things I want to talk about today. We've got quite a broad-based audience, which is understandable given the nature of the topic. Three things I want to sort of try to cover off, which will hopefully have a little bit of something for everybody. The first thing are some things to think about for every lender that is out there in the Pacific. The second thing are some observations about regional PPS, the personal property security regime, the secure transactions regime in the Pacific, and how that changes in different jurisdictions across the Pacific. And the third thing, which you can understand, you can't really give a webinar or have a seminar about the Pacific without making some comment on climate, and we'll just touch briefly on the Fiji Climate Act and implications in relation to that. So they're the three things we're going to cover during the course of today. So the first thing, some things for every lender. So the cornerstone of the banker-customer relationship are really looked at in my perspective in three different ways. The terms and conditions, which is sort of, you know, the bolts and braces of everything that you have between the banker and the customer, backed up by the securities, which run off those terms and conditions or will often sit next to it. And the third thing is what I call the free lunch. The free lunch is the thing which comes free out of the banker-customer relationship, the ability to have a really good personal connection with your customers and clients. And during my extended, long career as a lawyer, I've managed to have not just a few free lunches, but also enjoyed some great relationships with lenders and bankers across the region and obviously their customers as well. We can't do much today about the free lunch online, but we can do something about the terms and conditions and the securities. So I want to just talk a little bit about some terms and conditions and some tips and traps for lenders, particularly in relation to doing business in the Pacific. I can understand if there's some eye rolling going on, some people throwing their arms up in the air, worried about, really? I thought this was going to be interesting. You're going to talk to us about terms and conditions? Well, we are, and I think it's with good reason. So please don't lose faith in the presentation this early point in time. The terms and conditions part will, I promise, give you some interesting tips and traps. The most important thing is things change, as we know. Head office for a lender can change policy. There's product changes, terms and conditions with products change all the time. There's regulatory changes. Sometimes you don't get notice about those. And we even have a thing now called pandemics, which can arise without warning. So the important thing in relation to that is how can your documents respond to these changes which are going on all the time? And importantly, what is the ability of a lender to make changes to its terms and conditions easily? What are the local rules around those changes? How is notice required to be provided to affect those changes? And you also need to take into account local customs and requirements for those changes to be made. In relation to that, I have what I call the Rest in Peace award, which I gave to a head of credit for a international bank at one stage, who approached us to make changes to the terms and conditions upon which all of their customers in the region did business with them, because he didn't like the Pacific custom in some jurisdictions where customers would bury their relatives on their property. And he thought that it would be better for the bank if the ability to do that was removed, so that on enforced sale and other things, other opportunities, it would make things easier for the bank. Thankfully, we didn't have to go through and make those processes and process those changes, because he took into account the fact that it would not be very well received. So the RIP sort of clauses are ones which can arise because of local customs and requirements. So every lender makes mistakes. Let's just start that as a given. Every one of your documents with your relationship with your customer is going to have some type of terms and conditions. You're going to have your cornerstone terms and conditions booklet or leaflet or brochure. You're going to have terms and conditions which attach to movable property, like tractors or cars or other forms of plant and equipment. You're going to have terms and conditions which attach to your mortgage, your unmovable types of security. So what is the trap here, and which is a common problem for large lenders and small lenders alike and everybody in between, is that there is always conflicting provisions between these documents. All of those terms and conditions in all of those documents are never going to perfectly sit with one another. And the reason being is because they change over time, right? You don't change all of your documents at one point in time. So one document might get updated, another one might not. And it means you're going to end up with gaps or conflicts between your different terms and conditions in your different documents. So what flows from that is the obvious tip, in that your terms and conditions must have a priority clause where there is a conflict, right? It's an easy thing to say, but quite often we find that lenders have not thought about, well, if the you know what hits the fan, which document is going to be the paramount document, which document is going to stand up. So in that vein, these are the tips for what I call the 3 T&C certainties, which is not an easy thing to say. The tip is three things to check if you're a lender and to consider if you need to change. Right, the first thing is you must have a conflict priority clause in your documents. Why do you need that? You need that so it gives you certainty about what route to take on enforcement of your securities. It reduces the areas of conflict between your documents. It gives you the chance to avoid having to go to court because things don't stack up with each other, and therefore, dare I say, it gives you the chance to avoid paying legal fees. The second thing you must have is you must have an up-to-date notice clause, and you need that for lots of reasons. I call the notice clause in terms and conditions the middle kid, right? It's like having a house full of children, and the ones in the middle are always the ones that get overlooked. Once in a while, they'll put their hand up and get some attention, but the notice clause is often ignored or no love or attention is given to it. And I'll explain why it is important for you to actually read the thing and to make sure that it's going to work shortly. And the third thing you must have in your T&Cs in all of your documents is you must have somewhere a clause that facilitates terms and condition changes so that looking forward, you can make changes to your T's and C's easily. And we'll talk about that in a moment. So the first thing you need to do, accepting you need to have those three things documented or fixed, which is often the case, you need to work out what document are you going to amend to make those changes, right? The obvious tip is you've got to go for the document that gives you the biggest bang for your buck. You don't want to change 20 documents. You want to change one document. So try to work out what terms and conditions, what document has those terms and conditions, which will apply to all of your transactions. To recap, you will have T's and C's of some type in your letters of offer, your loan agreement, your specific security agreement, your general security agreement, your land securities, your guarantees, everything. They're going to be everywhere, right? So you need to work out what is going to be the paramount document which is going to have the T's and C's, right? The ones which you're going to change to deal with these three things. So making those changes, once you've identified what that document is, if you don't have a conflict priority clause, then you need to prepare one, right? And what I'm talking about here is something which is as simple as saying, in the event of a conflict between any of these terms and conditions, in any of our documents, the ones in this document prevail, okay? It's as simple as that. I can't begin to tell you how often we see lenders' documents which don't have that simple clause. It sets you up to give you clarity and certainty around your enforcement process and the steps that you need to take in an enforcement scenario. So that's your priority clause. Pretty easy to get done, pretty easy to check, pretty easy to fix. The second thing is the middle kid, right? The notice clause. So these are things that I think you do not want in your notice clause, right? None of these methods of delivery, I think, effectively work in the Pacific. Smoke signals went out a long time ago. The pigeon delivery system never worked in the Pacific or, frankly, anywhere else. Post. Most places in the Pacific don't have street names and numbers. So why would you have your notice clause saying we're going to give you, giving you notice on something by putting it in the post and waiting 7 days? The other thing, of course, is the fax machine. I can't remember the last time I sent or received a fax. I don't even know if I would remember how to use one. Yeah, when we look at all of our lenders and a lot of their documentation and things, so often they have, we can give you notice by post, discuss that, by fax. I mean, really, who has a fax machine? And those sorts of things. So you need to actually give this middle kid some love and actually pay attention to what it says so that in your paramount T's and C's, you can effectively give notice that's going to work. So they're the things that you don't want to have in your notice clause. What are the things that you do want to have? You want to have this, right? You want to have being able to deliver to a place or to a person. Okay, pretty simple. It can be pretty clearly drafted and is obviously very effective. The other thing which is really current and really important and we don't always see is you need to be able to effect notice of change and give notice to your customers by email. What you need to do is to make sure that your notice clause has those things in it and it does not have the other stuff which doesn't work anymore. To make sure that you can actually give notice by way of email, you will need to check in your jurisdiction the electronic delivery ability, right? Electronic transactions, legislation, the prudential guidelines from your central bank, any consumer protection requirements, those sorts of things. And you'll also need to check as to whether or not you need to notify regulators that you are including this as a method of giving notice to your customers. So they're the things that you need to have in that notice clause. So making future changes easily, this is the third thing in those T's and C's that we were talking about. Tip, as we've discussed, things always change. Looking forward, you want to easily make changes to your T's and C's so that as things change, you can effectively bring about changes to your contract with your customer in an easy way. As a general rule, there's normally two ways that you can change that relationship with your customer, right? The first is by agreement with the customer in some shape or form. That might take the form of a written agreement, or it might be an opt-out scenario in some situations. The second thing, which is preferable, which you should try to have in your T's and C's, is something which says, we can change these T's and C's by giving you notice of that. Okay, so it removes the requirement to get something countersigned by your customer. So that's what you need to try to work into your T's and C's. There are some footnotes about that last point. Again, you need to check your local rules and regulations as to what you can and cannot do in this scenario. In some situations, there are going to be some things that you may need to get approvals from a regulator or to give notifications to a regulator for. For example, in some jurisdictions, in some types of lending, you need to give a minimum number of days notice to effect particular changes, or you need the consent of the customer in relation to types of bank fees and different things. Some of those situations may not work in just giving your customer notice to effect changes. You may need to do more than that, but you will need to check the local rules and regs to be able to make sure that you can go down this path. If you need help with that, reach out to one of the PLN officers which are in your jurisdiction, and they can help you sort that out. So, why are we making all the fuss about this? I want to give you one example of a good reason why you need to have your notice clause in place and why you need to be checking your T's and C's for some particular circumstances for doing business in the Pacific. And it's one of my favourite topics. It's the absconding debtor situation. So where either the customer, he himself or herself has disappeared, or they're the principals behind a corporate borrower or guarantor, and they have disappeared. They've absconded, they've done a runner, they've left the jurisdiction. What do you need to do now in that situation? So what you need to be doing now is to be checking to see how your current customer documentation deals with that scenario. And the reason why I'm raising it today is twofold. Firstly, we are seeing more and more of this situation arising with the growth of intra-Pacific businesses and movement of people and businesses from one jurisdiction to another. And the second reason why it's relevant and it's important is because it shows you how important your terms and conditions and the simple things, those middle kids, the notice provisions and those sorts of things, how important those ordinarily boring things really are. So what you need to do, just considering for one moment the absconding debtor scenario, what you need to be doing is the following, right? You need to be saying, is our documentation currently helpful if that situation arose? Importantly, if somebody does a runner and escapes, then is that a default under your security documentation? Does that trigger some right for the lender to act on? What do your documents permit you to do or not to do if a person has left the jurisdiction? Why is this important? Okay, it's important to make sure that your documents can address this scenario, because if they do, and if your documents do work in this situation, then they short circuit the problems you could have with affecting service. If your documents don't work in this situation or are silent, you may end up having to go to court to get orders to serve someone out of the jurisdiction, or to serve it on a relative, or to do one of 5 or 10 or other things to make service effective. So the importance is making sure that you are able to address this situation in your documents. So your T's and C's must have two things in this situation. It must say that it is an event of default, and it must have a clause which says that in this situation, giving notice and affecting service on a customer who has left the jurisdiction can be affected in some way. So here are some tips in relation to that. You need to create an event of default in your T's and C's for the absconding debtor scenario, remembering what we've just discussed about your conflict priority provisions, and making sure that that event of default is going to go in the document which gives you the biggest bang for your buck. The other thing which you need to do with this type of situation is your clause needs to say that if the lender has formed a reasonable opinion that the person has left the jurisdiction, then that is enough, right? You don't have to actually prove that they've gone or that they're gone forever. So they're the sorts of things that you need to put in to cover this absconding debtor scenario, and you need to be able to have notice effectively served or delivered on that person in some way. So as an example, we've had situations where we have had to try to effect service on minority shareholders in really big companies where there's tiny shareholdings from 10, 20, 30 years ago, which is often the situation in the Pacific. There's no addresses. You don't know where people are. You don't know how to contact them. So you can actually affect service or notice on those people by way of things like service messages on the radio across the Pacific, or in other forms, using other forms of communication where you know in that cultural context, someone's going to give them notice as to what's going on. And if you're a lender and you want to look to see some good examples of this, if you have the time, or if you can get somebody else to find the time for you, to take a look at the way that telecommunication companies in the Pacific affect changes to their terms and conditions, then there are clauses in there which are really quite helpful and useful. I'm not advocating for stealing those things, but what I am saying is that they have been down this path for some time because of the nature of their business, and sometimes financial institutions are not as flexible or malleable as telecommunication companies, and some of this work has already been done. So that's somewhere to take a look. And again, your local rules and regs may have particular things to say about all of this. So this is the end of the first part for today. I know it's a little bit tedious, but the points that I want you to take away from the T's and C's observation is you need to make sure that they all work together. And that is not as easily done as it is said, and is a task that we find lenders are not very good at dealing with. You need to choose what is going to be the paramount setting. You need to have that conflict clause in that right document. You need to update your notice clause, right, to make sure that it is actually going to work. You should have things that cover the situations where debtors have left the jurisdiction, and you need to have a clause that enables future changes to your terms and conditions to be made easily and, where possible, by notice only, to the extent that you're allowed to do that. So, moving on. Second thing I wanted to talk about is the personal property security regime and what I call the same but different. And this is a particular area of law, but it is something which is now so common across so many different jurisdictions in the Pacific, I thought it was worth a mention. So the PPS secure transaction regime is in some parts same, in some parts same but different. I'm going to make some points in relation to the differences shortly, but as a throwaway observation, the creation of the PPS regimes in the Pacific was absolutely an opportunity missed by the international donor bodies who were responsible for bringing it in. The reason I'm saying that is because almost without exception, there is no reason for the legislation to be different in one Pacific Island country to another. Unfortunately, that is not what happened. The legislation was brought in spasmodically across different Pacific Island jurisdictions. Different consultants were used with completely different legal backgrounds, from Norwegian to American to English to Southeast Asian. So you're going to get people who understandably trying to do the right thing, but bringing their own legal heritage into the way that the legislation is created and ultimately is enacted. And unfortunately, I think it's an opportunity missed. It would have been a classic case, a classic opportunity for legal regionalism in the Pacific, and it is very much an opportunity missed. The reason why I say it's an opportunity missed is because the easy part for PPS is that the legislation in all of these places has the same foundations. They all start from the same ground level. So in every case, each debtor signs the security agreement describing the collateral, the lender gives value for that, and the debtor has rights in the collateral, and away you go. You perfect your security and onwards and upwards. And the means of perfection is almost universally the same across the Pacific. And that is the good news. So those parts, it is essentially same. The means of perfection of the security, essentially the same. Filing of a notice, possession of the collateral or control of the collateral, and so it's all the same. What I wanted to focus on now was just to show briefly a couple of examples about where things are different in that same legislation in the different countries in the Pacific. And the reason why I wanted to highlight that today was because of the trends of the growth of regional businesses in the Pacific, of cross-border Pacific businesses, lenders doing deals with taking security in different jurisdictions for the same deal, lending to a holding company with multiple subsidiaries, getting guarantees or individual securities under the PPS regime in different jurisdictions. And of course, for the staff who are online today, who work in these financial institutions, there is much more movement of people across the region who are dealing with lending and securities matters in the world of PPS. And it's important to recognise that the legislation is not the same in every jurisdiction. So simply, I want to show you a couple of examples of how it is different in the different jurisdictions. And this is what I call the go figure slide. So focusing just on aircraft, and I know some lenders in the Pacific don't lend to marine vessels or aircraft, but many do, right? And even if you're not in the Pacific, but you're lending into the Pacific, then you need to understand that there's nuances and differences in the PPS legislation in the different jurisdictions. So the slide, the go figure slide, speaks for itself. In some jurisdictions on the PPS regime, aircrafts are included, meaning you can perfect your security under that regime. In some jurisdictions, aircraft are not included. No logistical reason, no good reason why that should be the case. In some jurisdictions, you can perfect your security under the PPS, but if somebody else goes and takes security under the aviation law in the jurisdiction, that will take precedence. So you need to understand which is going to be the one that's going to work for you better, and it's not always the PPS. In some places, therefore, civil aviation law allows for the registration of mortgages so that you can have aircraft which have both a PPS security interest and a registered mortgage under the civil aviation law. So completely different scenarios in different jurisdictions. If you're lending in those areas, you need to understand those things. Similarly, the position is the same with movable collateral, i.e. it's same, but different. So just like you can have a person who absconds, you can have property which absconds, i.e. a person takes something which you have security of from your jurisdiction and takes it to another jurisdiction. Some jurisdictions, they have what they call continuous perfection rules, where it doesn't matter if that has occurred, your security will run with that property. In some jurisdictions, those provisions do not exist at all. Again, no rational reason why that is the position. So just like before, when we're talking about absconding debtors, the tip is, what does your T&C say where and if your security leaves jurisdiction? What can you do about that? So all of what I've said before in relation to people leaving the jurisdiction should also apply to property over which you take security. So PPS, same, but different. So on this second topic for today, the takeaways are clearly as follows. You've got to remember the legislation differs in the different jurisdictions across the region. And all I've done is given you a couple of examples of how there are lots of different ways that they differ from country to country. I don't know why, and I don't understand why. So don't assume if you're in this field and you're working with your colleagues in another jurisdiction, or you move from one jurisdiction to another, or you're working on a deal where there's security being taken over multiple locations, don't assume that what works in one jurisdiction will work in the other, because it is not the case. Property can abscond, albeit with the help of a person, just like people can. So go back to your T's and C's to check your cross-border protection in that situation. All right, the third thing for today, something to consider. And as I foreshadowed earlier, just wanted to make a brief comment on the Fiji Climate Change Act of 2021 and impacts on a few different people and things. So initially, impact on directors. So under the Fiji's Companies Act, and I think it's section 106, the directors have a normal duty to exercise reasonable care, skill and diligence. No big surprises there. However, the 2021 Act puts in a higher obligation on directors. It extends that normal duty by requiring directors consider and evaluate climate risks and opportunities to the extent that they are foreseeable and intersect with the interests of the company. Now, that is a pretty big obligation. It is actually what I call a positive obligation, which is imposed on directors. And it's not just on directors, it also extends to financial institutions and other bodies, which we'll talk about in a moment. The issue, I think, which is sort of the watch this space part for this, is whether or not other Pacific countries will be replicating this legislation or something similar to it. I do note that under section 93 of that Act and elsewhere in the Act, the ministry responsible in Fiji is to publish guidance notes and do different things to assist with compliance of this Act. The Monash Business School in May this year at Monash University in Australia questioned whether or not some of these sections are actually in play pending the publishing of these guidance notes by the ministry. So far as I'm aware, they haven't been published. If there's somebody here today who has better knowledge than me, feel free to share that on the chat. But having looked at the Government Gazette where this Act was proclamated, I can't see that that is necessarily the case. So to my way of thinking, should be assuming that these things are probably in play. So it's not just directors, right, which are impacted here. State entities get a specific mention. The Fiji Provident Fund gets a specific mention. Again, there's supposed to be guidance provided to assist with those sorts of things. And importantly, financial institutions also get a special mention. And I'll just let you know that in relation to financial institutions, two things. The first thing is that if you're in a financial institution which is operating in countries which include Fiji and other Pacific countries, this legislation specifically does not have any extraterritorial effect, meaning it only concerns itself with the activities of that financial institution in Fiji. The second thing is that financial institutions need to report a whole range of things under the provisions in this Act, including any material financial risks which are arising from climate change risks and climate change opportunities, the measures adopted by the institution to reduce its exposure to these material financial risks, how considerations of climate change risks are integrated into its investment policies, its risk management policies, and investment decision-making processes. So there are all sorts of things to consider with this legislation. Also, importantly, the penalties for breaches of the Act are particularly high. 10 years imprisonment and up to $750,000 in fines for certain breaches are very, very much at the higher end of the penalty scale for any legislation in the Pacific. And what is also important to recognise here is that third parties can bring actions for breaches of this legislation, right? So anybody who is himself, herself, themselves affected by a breach of the Act can actually bring an action ostensibly under that legislation. So takeaways for this last of our third topics, things you need to consider, take into account if you're a financial institution, you're doing something in Fiji, and this piece of legislation is in play. All of those things, if that is the case, then are your customers under your terms and conditions obliged to comply with the law in their day-to-day operations? Most of the time, that would be a yes, right? You need to check your terms and conditions to see that that is in fact the case. You need to consider climate impact obligations now imposed by this legislation on your customer and on its directors. Are they compliant with this or not? What is the implication for lenders lending to non-compliant customers? And indeed, what are the implications for lenders themselves with their own obligations to satisfy under this legislation? So for everybody, the point to take away from this is, if you are involved in a business which does business in Fiji, then you need to give this some consideration, notwithstanding the fact that it only concerns Fiji and not activities outside of that. We have on our website Directors' Duties Guides, which are a guide to different obligations for directors in most of our jurisdictions across the Pacific. So get online and track those down if you want to read about this. If you are, for some bizarre reason, interested in reading all about directors' duties, there's a really good read for you there. So go and get a hold of that. And I think also, as these guidelines come out from the ministry and as more and more of this comes into play, it's very much a matter of watching this space, not just for this legislation in Fiji, but also whether or not other jurisdictions are going to pick up and run with this sort of legislation as well. So there's a QR code and a very old photo, actually, there on the screen. Feel free to scan if you want to get in contact with us. Thank you everybody for joining. I can see a number of long-time friends and associates joining from across the Pacific. Really appreciate your time and connecting in some shape or form. Please stay in touch. Thanks everyone. Thank you.